Now that the state has closed their case, the defense can begin, and there's a little bit of a wrinkle I didn't cover earlier that I'll cover now. At the beginning of the trial, after the state has made an opening statement, the defense does have an option to give an opening statement, waive opening statement, or reserve opening statement until the beginning of the defense's case. Now, if the defense is calling witnesses, they may want to reserve. It's very rare that the defense would waive it, and normally they do their opening statement immediately after the state. However, at this juncture, let's say, for example, that first one was done, and the defense will then start doing exactly what the prosecution did. They will start calling witnesses. Now, if the defense does not want to call witnesses and wants to rely on the state's witnesses to beat them at their own case, then they won't call any witnesses. They will announce that they rest. The jury will leave the courtroom, and then there will be a second motion for a judgment of acquittal. Think of it again as a dismissal. And the judge will hear it, and let's say that the judge denies it. Well, then it's going to go towards the jury. At this point, the rule of how juries are given closing argument really will give you an idea as to how rigged the legal system is. For 148 years, Florida had a rule that said if the defense puts on no evidence other than the defendant testifying, they put on no evidence other than that, then the defense does closing argument, the state does closing argument, and then the defense has rebuttal. In fact, by act of the legislature, that's no longer the law. A procedural right that was given to defendants where both sides basically, depending on the trial, got a shot to go first and last was eliminated to favor the government in every case. Why was this done? Long before the Me Too movement, it was hard to get a fair trial in a sex offense case. And I've maintained for years that you just can't get a fair trial in a sex offense case. You can get it as fair as you possibly can, but is it really fair? No. Now, after the Me Too movement, absolutely not. Writers are out talking about the presumption of victim credibility. There's no such thing. It doesn't exist. But it exists in popular culture, therefore it exists in people's minds. And going back to an earlier video where we were talking about this, what matters the most? Facts and information or what people believe? Someone who's prone to be, in favor of convictions, who's prone to believe in this credibility of accusers, that's a real problem for lawyers in all kinds of cases, especially sex offense cases. But be that as it may, as it is now, the system is rigged in such a manner to where in every case, the state of Florida goes first, the defense gets to do a closing argument, and then the state of Florida gets rebuttal. That's in every single case. Does this affect how juries vote? Absolutely. If it didn't, the legislature would not have changed the law. And so where we are today, at this particular point in time, it's probably the hardest that it's ever been within the state of Florida for somebody to get a fair trial. And this is one of the reasons why the system is the secret. This is why we use trial teams and why we use an entire legal team in order to help you or someone you love if they have to take their case to trial.